we're not gonna read through the whole entire thing, I guess is what I'm saying. So do you guys hear, you guys want the lights on or off?
That's great.
Yes.
So if you're gonna do it exactly like you would do it with someone, do you want me to just come up and do it now?
That's a good point. So yes, so the way that I do listings now is I give them to my son. So he's gonna teach the rest of the class. So come on up. That's a good point. All right. It has been a while since I've done it, so.
Not complaining.
So he's the listing master?
What?
He's the listing master?
Yeah, he is the listing master.
He is
Yeah,
the listing
yeah,
master.
for me
Wait, is
anyway.
he really your dad?
Yeah.
Why
Don't you
did I
see the
know that?
resemblance?
I don't know.
That's so funny.
Yeah,
I love it.
So what's your
Yeah.
name again?
Doug.
Okay.
yeah. So yeah, when I get a listing now, I always call him and go, okay, here's the listing. All right, so we're gonna go through and we're gonna talk about it from the standpoint of how I used to explain it then. I don't know how Douglas does it now, but, all right, so, but here's the first thing to point out to you guys. Notice right here that this shows right under where it says exclusive right to sell listing agreement. It then says, in fact, let me hide these controls here. It then says, this is a legally binding contract. Read carefully before signing. Now, I point that out to you for two reasons. The first, which by the way, I don't say that to the client necessarily, even though I said I'm going to tell you how I would tell the client. I don't start it by telling them this is a legally binding agreement, but I want you guys to understand this is a legally binding agreement. And so if for some reason somebody wanted to have an attorney review it or whatever, then that's totally fine. But this is a legally binding contract. And what we're going to see as we go through this is that it takes the signatures of the clients and you on behalf of the company for this contract to be in force and in effect. So if that's true, if it takes them signing it and us to signing it to create it, how many does it take to get out of it? Yeah, the same, right? So just, and the reason I bring that up is this is a legally binding contract, but sometimes what will happen is either the agent, but more so it ends up being a client that will be frustrated, upset or whatever, and they will call and then say, hey, I want out of this contract because I don't feel like the agent's doing the job or whatever it is. But just them calling and saying, I want to be out of the contract does not mean they're out of the contract. It takes both of us to sign it to get in. It would take two signatures to get out of it as well, meaning from each side of the contract.
So for them to get out of the contract, because there is a termination of contract paper, isn't it?
We do have, something for canceling the
For
contract.
canceling the contract. Because I had a client that at the end of the 6 months that it was already gone, he still wanted me to do that. And I said to him, we don't have a contract, it's gone. I know, but I still want you to do that.
That's interesting.
Yeah.
I mean, it doesn't hurt anything at that point, but you're right. You don't need to. Once the contract is up, it's
Yeah,
up. So
it's
you
up.
wouldn't need to. Yeah. So cool. All right. So just keep that in mind. It is a legally binding agreement. Okay. So next, the next piece of this is the agreement is entered into and effective the blank day, month, and year between Century 21 Everest and blank. So what we're going to talk about mostly on this is how do we fill it in? So what's the date, obviously, that we would put in there? Yeah, the day you want it to be effective, right? So we're going to put in that it's entered into effective blank date. So the reason I point that out is that it doesn't necessarily mean that we're going to put today's date as the effective date. It might be that we're going to put that it's going to be effective next week or in a few days. A lot of times agents want to get the pictures taken before they have it go into effect, because once this is signed and it is effective, how long do we have to then get it put on the MLS? Used to be 5 days.
4?
No.
3. Next.
Yeah, I was gonna say, I think it's one day. Is
Well,
it one
No,
business
actually,
day?
no, it's 5 business days.
It is still 5?
It is.
I thought it changed to 1.
I'm
You would know better than me.
Yeah,
I know.
I'm pretty sure. I'm pretty sure.
All right. I thought it changed to 1, but
No, it's definitely not
You
1.
can't advertise a property for
Within
24 hours. Yeah.
You can do
If
24 hours before, actually.
Advertise it, you have 24 hours.
Yes.
okay.
Yeah.
You're right. Okay, good.
5 business
See, he is gonna teach the class. So, all right, so, okay, go. So we're gonna put in whatever the effective date is right there, okay? And then between Everest and the seller, where do we get the information to put for the name of the seller? Now, I know to some extent it feels like a little bit of a duh question, but it's really not.
Call it the time code, right? Or you check the tax rate.
Okay, good. So for me, usually the first thing I'm gonna do is go to the tax records to see. But I always just want to point out, don't 100% rely on that what the tax records say is going to be correct. It generally is, but I've had a number of times where it has not been. So let me give you a quick horror story that happened as a result of an agent doing this. So the agent had gotten the opportunity to get a listing, goes out, meets with the guy, checks the tax records. On the tax records, it had only this guy's name. So the agent goes and has the guy sign the listing agreement. And thankfully, the agent did what I'm about to tell you guys to do. As soon as you get this signed, you should immediately go down to North Star and say to Isabel, I need you guys to order a preliminary title report for me. We want to get that done right away. So the agent luckily had done that. And in the meantime, though, they put the property on the MLS, start to advertise it, and get an offer in. And in the process of them negotiating the offer, luckily, the preliminary title report, the agent got it, checks it. And one of the first things you want to check when you get the preliminary title report is who's on there as the seller. So the agent does, notices that it has this guy and then some other lady's name on the preliminary title report. So the agent calls me and says, what do I do? So what do you do if that were you, what would be the next thing you need to do?
Call the seller. Call the other person.
Yeah, you got to find out who is this other person. And then we need them to do what?
Sign up.
Sign the agreement, right? So the agent calls the original seller that he had met with and says, hey, I saw this other name on the preliminary title report. Who is this? And he says, oh, that's my mom. And the agent said, okay, well, we need your mom to sign the listing agreement, but we're also in the process of negotiating this offer. So she's going to need to sign the contract as well. Well, the guy says, well, my mom's on a cruise, and so she's not going to be available to sign. Okay, so now what do we do?
Yeah, what do we do?
You have to have her sign.
Yeah, we still have to have her sign, but yet we've got this offer we're negotiating.
Got the offer response deadline for a week.
So we have our response deadline or with offer and acceptance, because there's not really a response, but we have this time frame. So what do we do?
Tell them they gotta hold.
Yeah.
Okay.
But
There's nothing
what
you can
should-
do. You have to have her sign.
Yeah, we got to have her sign it.
And this might sound stupid, but could you have them still sign it and then do an addendum saying, hey, this person's on the as part, as the owner on the title?
Close.
Okay.
What we did is what I told the agent is I said, here's what you need to do is the next counter offer that you put in there, you need to put that verbally just tell them, hey, we found out there's another seller, but on the counter offer, make it subject to her agreeing to all the terms of everything that we've done. So basically what he did is send it back a counter. So they had gotten the offer and I don't remember what they were countering or how, if anything, but I said a minimum counter back that the offer is subject to the mom signing whatever her name was when she got back from her cruise. So he did. Thankfully, we had gotten that all taken care of, done that. So they then start to proceed as if it's under contract. Well, a week goes by and the agent calls the seller and says, okay, I need to get your mom's signature. Oh, well, she decided to go on another cruise, so we can't get her signature. Yeah, all of a sudden it becomes a little fishy, right? And so at this point, I said, just let the other agent know, hey, we thought we would be able to get her signature, but we haven't been able to get it from her yet. But, you know, give us another week. So in the process of this, they're doing their due diligence, right? They go do their inspections and everything. Well, the week goes by, the agent calls and says, I need to get your mom's signature. And the guy says, okay, here's, I don't remember if he got her phone number, they went and met, whatever it was. But when our agent then talked to the mom said, absolutely not. I will not allow him to sell the property. And she was furious that we had actually put it on the market. She was furious we had negotiated an offer, but luckily we were able to go back and say to the buyer, hey, sorry, like the mom won't agree to the contract. And so they were obviously upset and mad, but the mom said the whole reason because initially she wasn't on title, but he had tried to sell the home once before, and she was the one who paid for the house and paid cash for it. He went to try to sell it once before, and she was like, no way, like it's really my money, you're not selling this house. So she had done a quit claim deed to have him put her on title with her, but it hadn't shown up on the tax records. So that's the whole point of this, is like, take what the tax records say, but don't 100% rely on that they are all the way accurate, because they're not always accurate.
So Ross, how can we avoid getting into that kind of mess?
Yeah, the challenge of getting into that is, unless this, like, if you check the tax record, I mean, I guess the only way would be to order the preliminary title report or go to the title company and have them pull it up first.
Which is easy peasy. We'll do it
Yeah,
for you.
yeah.
Okay.
You have to
Or
have someone sign though, right? I could be wrong, so Isabel might have to correct me.
Okay.
I talked to Dave about that because other title companies we use, they don't like you to do that unless you have a listing agreement.
Correct.
Because it charges them money.
Correct.
But Dave has told me that in North Star, they worked out a deal with whoever they use, that it doesn't charge them to do it, so they're happy to.
So just to pull it up or to order the preliminary title?
So order the report.
So Isabel,
I could be wrong.
did you hear what he said?
Sorry.
No, she wasn't worried.
I know, that's why I was like,
So I had a
Aiden was
situation
distracting her, but that's all right.
Yeah.
where Dave told me to just go order it anyway.
Yeah.
But other companies have not wanted you to do it because of the costs. But he said you guys worked something out to where it wasn't.
No, we're happy to pull the reports for you. Yeah.
Even if we don't have it signed yet. Obviously, you want it.
I'll
Further
I'll
than
text-
maybe.
I'll
I don't- I
text
could be
Crystal
wrong.
right now, but I've talked to her about this in the past, and
Yeah.
I don't believe that there's an issue. I'll double check.
Well,
though.
but I
I'll
think
text
they
her
can
right now.
pull it, you can pull it though really quickly
Yeah,
to see
yeah.
who's the
Well, that's
order
what we're
is.
here to do
Even
for
if you don't
guys.
order, so you don't necessarily need to order the preliminary title
Yeah,
report, but.
yeah. No, honestly, like, I mean, obviously, please like work with us, but it's not like you have to sign anything saying you work with us or anything, or like sign any paperwork with your clients before having us.
Well, and I don't know that this happens anymore, but when I first started, when Douglas was first born, that's how long I've been licensed.
Wow.
He was a couple months old, but it used to be, what happened is one of the title companies had told me that every time we ordered, as an agent, you ordered it, they have to charge you for that. And so what would happen is, back then, is once a month, they would print off this ream of invoices that was like this thick of all the people who had ordered stuff. And then as soon as it was printed, they would immediately take it over to the shredder and shred those invoices, because they don't have to collect, they have to charge you for it, but they don't have to collect. They don't have to force you to pay it, basically. And so,
Yeah, I know for a fact
I
that
don't
we
know if
don't,
that's so true.
we don't,
I
we
think-
will not charge you to pull
Right.
her reports.
I was
Yeah.
also gonna say, Russ, another good idea to have a gate is to ask the seller, is there anyone else on title? Because a lot of times
Yeah.
they know, and they just don't think it's a big deal.
Yeah.
They don't think they need to sign.
Yeah,
They
so,
passed away or something, trustees, LLCs.
yep, very good point, is you can ask. Now, in this scenario, the one that I just told you about, he would have said no. So it's not a guarantee, but absolutely, it's a good idea, just, and part of that would be just during your pre-qualifying questions, is asking them before you even tell them you've looked on the county records, who's on title. So who are all the decision makers? So,
That was just the line, right? Like, you did your due diligence, right? If you asked and then he told you no, he fucking didn't. Like, you're doing your job.
That's right. Yeah, and that's just it, is that in that scenario that I gave you, the agent, the buyer's agent, of course, was furious, but we just had to say, look, we were, just as, yeah, we didn't know, like, we're just as upset because we just lost the deal too. It's not like we knew and we're trying to be sneaky. The client was, we weren't. So anyway. All right, so that's how you're gonna do on the seller. Now, the other piece on that, while we're there, before we move on, is in the event that what happened was it ends up being a trust, that the property's in a trust or a corporation, then what do we need?
Corporation.
Good, yeah, so, or the trust, it's, showing who has the right to sign. So one of the things that I recommend to do is when you come across a scenario like that, where they say it's in a trust, or if it was in a corporation, I always just say to them, the title company is going to need a copy of either the trust or the articles of incorporation showing that you have the right to sign on behalf of that. So will you get me a copy? Now, so it's not like I need it right off the bat, but that's kind of my way of just making sure they're gonna be able to provide it to me. Okay?
What's like the specific difference between the articles of incorporation, and just like the trust? You said get the trust or the articles of incorporation?
Well, the articles of incorporation would be for a if it's an LLC, if it's corporation.
Oh, okay.
The trust would be just if it's,
Trust.
yeah, if they put the property into a trust.
Would it, and like a lawyer have that, or how would they?
No, they'll have a copy.
They'll just have a copy?
They'll have a copy of the trust. Yep. And there'll be a section in there that says who has the right to sign on behalf of.
What is this? Trustor? Oh,
Trustee.
Trustee.
Yeah.
Really? The one making the trust?
I-
Okay, sorry.
The trustee is who's basically
There's so
the,
many
Yeah.
variations. That's a very complex answer.
yeah,
Sorry to waste time.
no, that's good.
No, it's
But-
fine, it's fine.
But for me, I always just say I need to get a copy of it. That way I know I have the right person that's able to sign. Now, I'm not gonna not go with the listing and like if they don't have a copy right then, but I'm gonna say I need one like ASAP. And I say that we want it for our records here at the brokerage, excuse me. I say that I always tell them that the title company is gonna need it, which is true, they will. But I'm saying it from the standpoint of that we need it, even though technically I don't know that we need it, but the title company will, okay? Make sense?
In that one, I had one at trust, and the son was trying, I mean, with the dad's knowledge and an agreement,
Uh-huh.
he was trying to help him with the sale, but he was not as a successor trustee. He was the dad and the mom, and the problem in there was that mom had dementia. So they needed a doctor to certify that she was not competent for signing. So it took a while before the son was established. And I think it was title company that helped us. Yes, it was the title company that helped us to establish the son as a successor trustee. Because that was an agreement, mom didn't know anymore.
Yeah.
So they wanted the son to handle it.
Yeah, that's great. Perfect. Yeah. All right. Any other questions on the seller part? All right, next thing. So next thing down is the terms of the listing. So the seller is granting to the company, including, and then you're gonna put in your name there as the seller's agent, that you're authorized until 5, so it's gonna end at 5 PM on blank day, month of year. So what should we put in for the date? How far out should we put it?
Depending on the contract,
6 months, 1 year,
depending what they want to.
Whatever you can get away with.
whatever you can get away with. Okay. So here's how I like to think of it is I always think of it from the standpoint for me is I think of it as I want to have a minimum of 4 months is what I think. Now, so we typically the answer you're going to hear is 6 months, but for me, like I personally don't really want a listing for 6 months. And here's my thinking on it is what I have found is if I cannot get the property sold within 4 months, typically months 5 and 6, the seller are so frustrated. And the reason it's not sold is because they're not adjusting to what the market is telling us. And so for me personally, I'm just giving you my personal on it is I usually like to do 4 months. But as a company, I think probably if Rob were in here, he'd probably say do 6 months. So somewhere around there. But for me, again, I just look at it as if they're not going to follow our pricing strategy, then we're probably not going to get the property sold. And I don't want to be holding on. I've just found after about 4 months, if it's not sold, as a general rule, they're pretty frustrated.
So Ross is not, I saw an agent that her for sale sign wasn't hanging in there for 6, 7, 8 months. And looks like the contract died, but she never retrieved her for
Person.
sale sign. And I think she was thinking, oh, well, people will see that I'm selling this house
Mhm.
and I'm getting,
Phone calls. Mhm.
phone calls. So wouldn't that be a valid reason to try to do the 6?
So, yeah, so that is a good point. Yeah, if you want to look at it from the standpoint of if you're looking to get more buyers from it, then yeah, you might want to say, I don't care if it stays up there for 6 months, and yeah, that could be true.
It's like a huge violation though, right?
Well, oh yeah, thank you. You still have to have a contract. Yes, sorry.
Yeah.
I mean, yeah.
But yeah, if your contract's over, get your sign down. Sorry, I thank you for, but,
Yeah.
I was thinking from the standpoint of maybe you want a 6-month listing so that your sign is there for 6 months. That could be. I just found for me, I want my sign up for a short period of time because I want the other sellers in the neighborhood looking at me from the standpoint of that's who we want to sell, help us sell our home. And the longer it's there, the less they're gonna think that way. So-
Okay.
So anyway, just depends if you want buyers or sellers. So again, for me, I typically am not gonna do less than 4 either. Somebody says we want a 1-month listing. I always say to the seller, look, we're gonna be spending time and money marketing your property, and I at least wanna know we're gonna get the opportunity to get the property sold. So like I say, for me, it's typically a minimum of 4 months, I guess is where I'm saying that I look at. Make sense? All right. So, and again, that ends at 5 o'clock. Unless otherwise stated, like our contracts are going to be typically ending at 5 PM. Okay.
That's really a relevant question for me, because it's like, I do all my response deadlines for like 8 o'clock, just as always, you know, it never ends up being 5. And then later on, like deadlines, so where does it say that all the deadlines are at 5? 'Cause
So
if it offer response 8.
In the Rep C, there's, I can't remember what section, but it's the time is of the essence section, says that all dates are all the dates will be met is 5 PM unless otherwise stated.
Just one addendum to whatever that section is. So you write it.
No, you don't have to do that. If you just on your, when you're putting in your offer and time for acceptance, if you put in a different time, that automatically just becomes the time.
Well, I mean, like for deadlines now too.
Oh, if you wanted to, yes, you'd have to do it on addendum if you're wanting to change that. Otherwise, it's gonna be 5 o'clock, because yeah, the time is of the essence section says it'll be 5 PM. All right, okay, next. Has then, the next blank line is the described as, where you're gonna put in the property address, so you're gonna put in the address of the property there. And then that's good for section 1. All right, section 2, brokerage fee. So on this particular one that I get, the copies that I handed to you guys are different than what's showing on the screen. So for you guys on Zoom, what you're seeing on the screen is an older version. But the copies, the ones that we have now, just has a blank line versus on this one here that you're seeing on the screen. And the reason I use this one is so that you don't just think blank line, but is this one is showing a 7% plus a 495. Okay, now. The one that our contract that have now in dot loop, I think in dot loop is only blank line, right?
There's both, I think.
Is there both? Okay.
Just totally different.
So, but don't just automatically go to 6%. The reason I still have used this one here is just know that it is possible to get more than a 4 or 5 or a 6% listing, okay? I have done a lot of 8% listings, and one of the contracts last year, that a listing that I did do, when we were out meeting with the seller said, so what's the commission gonna be? And we said 7%, and she goes, oh, so it hasn't changed. So don't just assume that everybody out there thinks that you should do it for 4 or 5%.
Well, then if you start higher and then they negotiate you, if you have to get it lower, then that makes sense.
Yeah, and here's the other thing on that. Don't automatically go in 1% increments. So if you told them 7% and they want to negotiate, go to 6.5. Like, don't just automatically go 1% down, to 6. But my first listing I ever got. So I had gone out door knocking, first time ever door knocking, and I had said to the agent that I went door knocking with, what do I do if somebody says yes? And he goes, oh, they won't. And I was like, oh, well, then why are we doing
Yeah,
this?
why are we doing this?
But he said, well, just if they do, tell them you'll come back later. So I go out and I knock I get to on the street I was on, the very last house, knock on the door, and the guy opens the door. I talk to him. He says, yes, I want to sell the property. I go back to the office. I go to my manager and I'm like, okay, now what do I do? So he gave me the listing agreement, said, here you go, just have him fill it out. So we go out there, I sit down with the guy. I'm going through the contract. I get to this brokerage fee section. And I say, and the commission's gonna be, and I was assuming 6, and I look down and it says 7, and I'm like, 7%. And he just goes, okay. And So I go back to the office, I turn it into the office. Our next sales meeting the next week, our manager gets up and he's like, all right, guys, hey, we want to recognize Russ because he got his very first listing and everybody claps. And he's like, but hold on. He got it at 7%. And everybody in the office was like, what? That's so cool. And I was like,
Yeah, it is cool.
but it says 7. Like, I was like, I didn't know I could do anything different. So my point on that is sometimes just ignorance is a good thing sometimes. So don't just assume that you got to go in at 4 or 5 or 6. Like, be willing to do a 7 or an 8. We've got an agent that is in the Centerville office by the name of Trent Hyde. Trent, during the downturn in the market, so during 2009, 10, and 11, he was doing 8% listings all the time when the market was going down like crazy. Now, and I don't agree with how he did it, but this is how I always did it and got a 7 or an 8, is I always would offer half of whatever I was getting. So I would offer a 4% on the MLS to whoever brought in the buyer if I got an 8% listing. Well, Trent would go in and tell the sellers, we're going to do it at 8%, and he would offer 5 on the MLS. Now, if you were representing the buyer and you saw that you could get 5%, you're going to want to show that listing? You're going to be a little more,
Call people that aren't even in the market yet.
what?
You call people. that
Yeah,
weren't
see,
in-
that's the thing, is that's part of what I want you guys to see, is that part of what our job is to help the seller to see it really is to their advantage to offer a little bit more on the MLS, not less like everybody else is doing. Okay, in fact, I had an agent again last year from this office came into my office, said, hey, I just got this listing and I took it at 7%, and I'm going to offer 2 to whoever brings the buyer.
Wow.
And I honestly said, get out of my office. Like, I'm not even gonna, don't come talk to me, because in my opinion, that's wrong. Like, don't do that. So anyway, don't just assume you're gonna get less.
So Ross, if somebody's getting the 7%, I haven't never done that, but if somebody is, should it be published 3.5 for the other party?
Well, I mean, it's up to you to decide. I always did it that way.
You did half.
I always
exactly
just
half.
did half. So that's, I would go in, that's how I would get an 8% listing, is I would go in and tell them, I'm gonna charge 8%, but I'm gonna offer 4 to whoever brings in the buyer.
Okay.
And again, stop and think about it. If you're showing property and you know you're gonna get 4% or 2 on the next house you're gonna go see, now I wanna be clear, our fiduciary duties, we should trade it no differently, right? But reality is, you're a little bit more excited if they want to buy that property. You're going to probably, if they want to go in and make a lowball offer, the agent's more likely to say, I don't think you ought to do that. Like, and once you get it under contract, you're going to try a little bit harder if you're the buyer's agent to keep it under contract. Like, after they've done their inspections, you're going to try to be a little bit more like, and I get it. Like, I know 100% our fiduciary duties, we should not do this. I just know reality is the agents are going to want to try to keep the deal together. And I would present it to the seller is, to some extent, the agent's going to become more of your advocate than the buyers, because they know if you cancel the deal, meaning if they came back and asked for repairs and you say no, and then the buyer cancels, that agent knows they're going to go get less money on a different house in the same price range. So they're going to do everything they can to keep the deal together, and probably not nickel and dime you as much, is kind of how I present it to the seller.
So
Same
last
thing.
comment, I heard of another agent that he was really upset because he found out at closing that the other agent charged more, but offered him just
2.
2. And
That was probably our agent that I was talking about. I'm just kidding.
anyway, but really, there is no way that the selling agent know unless it's at closing, right? Because there's nowhere in
Right.
there to read it, how much the other one got.
Yeah, I know there has been talk about putting that on the MLS to have it have to show both sides. I don't know that that'll ever happen, but there's been talk of that just because of exactly what
Pretty
you're
sure that's how
saying.
it is in Oregon.
Is it?
Yeah.
You can see what both sides are getting.
Because that would be great, really.
I mean, to some extent it could be good, but I also feel like it's really not the buyer's agent's business. The buyer's agent should have come in and negotiated for more, like on that scenario, that agent should have come to the listing agent and negotiated to get paid a higher buyer agent commission.
Yeah, because he says he was just so upset when he found out that he charged full commission, but he gave him
Go,
just two.
yeah, so that person probably kept 4 and gave 2.
Yeah, that's right.
That's why you get it listings.
That's why what?
That's like you get listings, isn't like.
Yeah, then
charge
you're in more
everyone,
control, yeah. Okay, good. So then the other side of this is the plus the 495. And on that, the plus the 495, where that came from, usually people have questions, usually as I'm teaching the class, although it's become less and less, which is, that's kind of a good thing, I think. I guess, I don't know, but I've had less and less agents asking about, why do we have to charge that? And so what is the reason? Do you guys know why?
Specific to Century 21, or is that a Utah?
It's a good question. So it's,
Is it, hold on,
okay,
is
go.
it 495?
Sorry, no, that's what I was just gonna say. It's 295 is the minimum that Everest requires for view. So when you signed in with Century 21 Everest, you agreed that you would charge your clients a 295. Now, a lot of agents end up, I shouldn't say a lot, some, you probably know better. There are some that just pay that themselves. They don't want to charge it to their clients.
Like half, I'd say.
Probably half, yeah.
Yeah.
So now early on, let me give you kind of the background on this and where it came from. Well, why do you guys think we would do it? That's what people say.
That's what I was told.
That's not true. I know that's the problem is that's why I'm bringing this up in here is a lot of times what people get told of why we do it is not really the reason it's done. And so I'm going to give you the truth. I just believe power comes out of telling the truth. So I'll give you the truth. Okay. Now, so let me go back though, and somewhat to answer your question on it as well, is that it's up to each company, but most of the name brand companies in Salt Lake or the Wasatch Front will charge it, some version.
Interesting, I've never seen that.
So let me give you kind of the background of where it came from. So when I first started, I was with Coldwell Banker. And for the first about 2 years that I was with Coldwell Banker, we didn't charge it. But what ended up happening is when I first started as brand new agent coming out of the gate, just getting their license, never, ever would get higher than a 50%. Like you started on a 50-50 with the company, then you had the franchise fee on top of it. So really you were more like a 44% is what your split was that you were getting. But splits became very competitive over the last number of years to where, and actually, let me say it this way, there were no caps. The highest an agent ever got was 80%. Even top producing agents would never get more than an 80%, which again, then you minus off the franchise fee. So 74% was the max an agent would ever get paid a commission. Well, that became competitive between companies and they started offering higher and higher. And then all of a sudden now throwing in caps and all that kind of stuff. And so as a result, what happened is companies started to notice that there are a lot of the top producing agents would go in and do this. They would charge a 6 or a 7% commission plus like $195. And so what happened is, and I don't know that I can say this for every other brokerage, but Coldwell Banker was one of the first to do it. And when they presented it to us as agents, they came to us and said, hey, we're going to now start charging this. And back then it was called a compliance fee. And the way that they sold it to us as the agents was, we're going to hire a paralegal that will look over every single contract to make sure that it was done correctly. So then we would go out to our clients and we would say, we're charging this and it's because we're going to have a paralegal look over your contract. Well, HUD found out that a lot of companies were doing this across the country and came out and said, you can't do that. You can't call it a compliance fee because that's not what it is. You got to call it what it really is, which is, and so then it changed to, it was going to be a transaction fee. And sorry, no, that it was transaction fee first. When HUD came and said, you can't call it that. So then they changed it to compliance fee. HUD got a word of that, came out and said, you can't do it that either. You have to call it what it truly is. So what it truly is just additional commission. And the reason for it is because agents started getting too high of commission splits. And at one point with Coldwell Banker, there was 1 year that the profit that the company made was, if you divided the number of transactions into the 195 that they were charging, that was the whole profit of the company. Without it, they wouldn't have made any money. So it kind of caught on to other companies. And so That's probably, because in Oregon, I'm assuming that nobody does charge
Yeah,
that.
no, we just have like our split, like my brokerage up there. It's
Yeah.
just like a flat split.
So ultimately what happened is it was just a way for the companies to be able to make a little bit more money because of the splits and all that. So if you guys want to get rid of it, all we have to do is go back to nobody ever gets higher than 80% and no caps. Who's in favor?
So.
Oh, you
so
guys said so.
Now how do I explain that nowadays, if I'm doing it?
Okay, good question. Yeah. So here's what happened with me. I struggled with this for a long time when it was the 195. I had a big struggle with it because I would go in and what I found is every time I would present it to the sellers would all of a sudden have issue with it. And I would have a struggle with it. And then what ended up happening, which I think is still what happens, it sounds like half the time, is agents are so worried about it that they just go, I'll just pay it for you. I'll just pay it for you. And so then it just comes out of the agent share of the commission. And I did that for a while until one day I was doing a seller net sheet for the sellers. And when I was doing the net sheet, I was looking at all these fees and I went, wait a minute, like the clients have no problem with any of the rest of these fees. They never question these. Why are they always questioning the 195 or in this case, 295 or 495 here?
Because it's right here, that's why.
Well, no, because it was in, yeah, well, and I guess to some extent, maybe, but what it hit me was if I will treat it just like all the other fees, the title, the title insurance, the fee that they charge to do the closing, their taxes, like all the other stuff that goes into it. I was like, if I just treat it like that, I'm going to see what happens. So I would go out and before I would ever even show the clients this, I would do a net sheet for the client where I would break down everything. The other thing I found is that helped me in getting a 7 or an 8% commission as well, is when I would do the seller net sheet, I did the net sheet based on whatever commission I was going to charge. I didn't write the commission of the percentage. I wrote the dollar amount. And then I would put it in the net sheet and show the seller after you sell and pay all the fees, this is how much money you're going to walk away with. Does that look like it will work for what you need? And if they said, yes, that looks like it will work, then I would just say, great. Then when we got to here and I would go through and say, okay, it was a 7% commission plus 495. If they were like, what, 7%? I would say, yeah, that was the number I showed you over here. This is what it was. And they had already agreed to it. And I found that, and actually, let me back up. I usually didn't even really I didn't point out the commission here because we had already done it on the net sheet. So I would just say, when I got to this section, I would say, basically to the seller, what this section says is that you're going to pay me a commission, that it's going to be due and payable at closing. So I work for free till I get the job done. But they've already agreed to the seller net sheet.
So you didn't put an amount in there?
No, I had it in here. I just didn't point it out to them. So
I will say too, back to what I brought up in the beginning with us being a resource for you, we do have a net sheet calculator on our northstartitle.com website. We have a couple other tools on there for you guys just to help you out. So feel free to use that anytime. And I did find out an answer.
Okay.
So yeah, no, we can pull the preliminary title report for you guys anytime. There doesn't need to be anything signed or anything like that. Just, that's what we're here for. Just stop by and have us pull one for you.
Perfect.
Okay, I do have to take off.
You're good. Okay, thanks for being here.
Guys. Good to see you
Thank you.
guys.
All right, so ultimately this additional commission, this is really just additional commission, this 495. Now, the way that it works too, so Aiden, this part, a lot of times I've found either recruiters or brokers don't explain it properly. A lot of times what they will say is 295 of that 495 goes to the company. And then the additional that you charge above 295 is yours to keep, which is not true. It's on your split, it's yours to keep, but it's based upon your split. And so sometimes I know what the recruiters and brokers will say is if you charge a 595, that way it'll cover the 295 plus the transaction coordination, which it will cover your split portion towards that, but it's not going to cover the whole thing. So I always point that out because a lot of times an agent will come to me and go, hey, they told me if I charge that essentially the client's now paying for it, but it depends on what your split you're on is. So because you will get, so let's say it was, well, in this case, the 495, the $200, you're going to get whatever your split is of that. So if you were on a 50-50 split, you're getting $100 out of the 200. Does that make sense? So, all right. And just so you know, just in case, so like, you guys, if you are worried about it when you go out, we did have an agent here that I sat in on a meeting with the seller, and they were a little mad. But the agent charged a 7% commission plus 900. No, it was like $7,000 or something. Do you remember the amount?
What?
I can't say, I don't want to say the name of the agent, but yeah, well, the seller was ticked at it, but I was like, well, you signed the contract, but so because of that,
Snuck it in there.
as a company, we now say you don't go above $995. So that's kind of the max, but it was 4,000. So she did 7% commission. I shouldn't have even said she. He or she, this person charged 7% plus $4,000. Now, when I asked the agent, why were you charging an additional 4,000? She said, well, there was some extra things that I did. And I was like, but like what? And I couldn't get an answer. So anyway. So the point being, like,
I did that for my last listing in Oregon. It wasn't set up this way, but I had gotten my junk removal done for them, which ended up being like $2,500.
Oh, okay.
So they, like tack that on top of my commission, which is like.
Yeah.
You know, reimbursing, but.
so that's just it. If it was something like that, I could potentially see, but you better have a pretty good reason. But I have had scenarios, and we'll potentially see this later in the market, where I had with my nephew, I was helping him buy a property where we had asked the seller to pay like 5,000 in closing costs, something like that. But then the lender couldn't use they only used like 4,300 of it. And they were like, I don't know what to do with the other $700. And actually it was even more than that, because I said, well, let's do a 2-year home warranty instead of 1-year home warranty. Like, we did everything we could to spend it. And then when we couldn't do anything else, I then did an addendum and charged I charged like $700 in a fee. But because it was like, we might as well get it.
Like with what do you mean?
Because
I did an addendum to the buyer broker saying that instead of it being a $495, it was like a $795
Yeah,
or something.
for why though? Wait, so what do you have to?
Just
spend
because there was
money?
money left over that the seller was gonna pay towards the buyer's closing costs.
No.
And the lender couldn't use it all. So I was like, well, then I'll take it.
so Ross, if you didn't do that, what would happen to that example?
Would have just gone back to the seller.
Yeah,
Yeah, if I hadn't done the addendum and increased it, it would just gone back to the seller.
And you saw fit to do that just because the seller already agreed to the amount.
Yeah, and I talked to it was my nephew, and so I just talked to my nephew and just said, hey, here's the scenario. We can either give it back to the seller, or we could change this and it'll go to me. And he was like, well, I'd rather you get it than the seller. Okay. Then I bought him a really nice closing. All right. Any other questions on brokerage fee? All right, next then, protection period. If within blank months, what should we put there? How much? 3? Any other thoughts? 2? Do I hear 1? So for me personally, I actually usually put 1, but it's blank. You can put whatever you want. Here's what I will tell you though. Put something in there. Don't put 0. Put a number of months, whether it's 1, 2, 3, whatever you want to do. Here's how I explain it to the seller. When I get to this section, here's what I say to the seller. This section is just to keep honest people honest, is what I tell the seller. And I just tell them, because basically what it says is after this agreement expires, if you were to sell the house to somebody that I showed it to, or that looked at it during the term of this listing, we would be still owed the commission if that happens within blank months. So if you want to do 3, do 3. I usually just did 1 month, because I was kind of like, I'm not going to worry about it after that. But however you want to do it, 1, 2, 3 months, somewhere. If you want to do 6 months, do that. But we had an agent here that had a listing, had an agent from another company had showed the listing while it was listed. And then within a week, their listing expired. And then the buyer that had looked at it with the agent during the listing went back and wanted to buy the property and put together a deal without our agent being involved, because it was after it had expired. And our agent came back saying, I should be paid a commission on this because they looked at it while I had the property listed. Well, the first thing I went and did is looked at this protection period, and it said 0.
Oh,
So there was zero protection on that.
So there was no claim.
So the agent was saying I should be paid a commission, and I said, well, actually, I don't think you should be, because you put down that if it happened after that, it, didn't matter. So for me, I would say at least put some time frame in there, whether it's 1, 2, or 3, just so that you do have a little bit of protection if that were to, because that agent, had they put 1 month in there, I think they would have had a right to go back and say, I'm entitled to the commission.
How about if the month was there, but the seller asked her to sign a cancellation of offer? Will that have any weight on that?
If, meaning what you were talking about before, the scenario?
Yeah.
I don't think so, because this says if within blank months after the termination or expiration of the agreement, it's acquired by a party to whom the property was offered. So I don't think it would have mattered.
No, question, if to claim that you have to have like show it to the other party, or how do you make that connection? What is to say, hey, that was my client and I did talk to you, what kind, do I need to have a showing or they?
Yeah, you would,
put a
in that,
contract or
yeah,
what?
in this scenario that we were just talking about before, yeah, what you would have just been able to show that they opened the key box to show that that agent had shown the property.
Okay, because just inquiries doesn't really count, does it?
No.
Okay.
No,
Coming through.
no. Well, and I don't know that it's necessarily to and through, but it says was offered, or, well, I guess it does say was offered or shown by the company. So I guess
Well,
offered, but
The reason I'm asking, because I had a client for over $1 million property that the city inquired when I was a selling agent. Anyway, and they said, your client is asking too much. By law, the city cannot offer what your client wants, because my client wanted 1,800,000.
Okay.
But anyway, after my contract died, guess what happened? They changed the city people, and then it said in the county records that it was sold to the city for 1,800,000. And I was thinking, what happened to the by law deal?
Yeah.
But they just inquire, and in that case, I mean, I did. They never came and saw, and they didn't need
well,
to
here's
see
what
it.
I would tell you. I would have tried to go after it for the commission from the seller to say you owe us the commission because this does say the property was offered or shown.
Yeah,
by the
because
company.
I just find it fishy that he asked the
Yeah, that
seller asked to every agent, do not contact the city, do not, and he ended up selling it to the city.
Interesting.
And I was thinking, that's
Yeah,
weird.
that is weird. All right, we good on protection period?
Yes.
All right, next, seller's warranties and disclosures. In this section, when I get to this with the seller, what I'm doing is just explaining to them that this section says that they are warranting that they have the right to sell the property. So this ties back to where we were saying that you've gotten all of the signatures, if it's in a corporation or it's in a trust. Right here is where they're warranting that they have the right to be doing that on behalf of this trust or the corporation, whatever. The other thing I tell the sellers is that this says is that you will disclose everything that you know about the property. So I'm telling the seller at this point, you're agreeing you will disclose everything that you know about the property to the potential buyer, okay? And then typically at this point, I would go right to the seller disclosures and give them the copies of that and explain to them what they need to do, but we've got it later on in this packet, so we'll get to it in a minute. All right, we're gonna pick up the pace here a little bit because it's been 54 minutes and we're on section 5. All right, agency relationships. So when I get to this section, I just am explaining to the seller. And here's the thing, and I don't know, maybe it's just me, but a lot of times I feel like when I'm working with a client that they think they're negotiating against me, like that we're adversaries. And so when I get to this section, I use this as the way to tell the seller, we're on the same team. Like I am here to fight for you. So what this section is saying is the duties that I owe to you as a seller's agent is to look out for your best interest. So I'm on your side. I'm going to try to negotiate everything I can to help you get the very best. We aren't adversaries. We're not negotiating against each other. I'm not trying to get you to do something you don't want to do. Okay. And then I say, there may be a scenario, and so section 5.2 is talking about a scenario where if a buyer calls me and wants to see your property, and I go show it to them, in that scenario, I may end up being a limited agent. And then I just tell them in that scenario, basically what it means is that I just have to stay neutral. I can't tell them the least you would be willing to accept, but I also can't tell you the most they would be willing to pay. And I just explained to them that it's really no different than if somebody showed up with a different agent. If somebody showed up and they had a different agent, I wouldn't know the most they're willing to pay. And I wouldn't know a lot of those details. In a limited agency scenario, I might know them, I just wouldn't be able to say anything to you. So I did have one time that that this became a little bit of an issue, that where I had a seller who had told me, we want to list at this price, but we'll go down to as low as this price. This is our bottom dollar. I had a buyer call me, said, hey, I saw the sign, we want to go see the property. I went and showed it to them. They said, we want to write the offer. Great. We went back to the office, sat down to write the offer. And I said, so how much do you want to offer? Now, remember, it was listed here. They told me they would accept this. They said, we want to offer this. It was the bottom. And I was like, oh, okay. So I wrote it up, took it to the seller, sat down, and the seller was like, this is a little fishy. Like, we told you that was our bottom dollar, and now you're bringing us an offer. And so for a long time after that, I would tell sellers when I got to this section, don't tell me the least you're willing to accept. And I would usually tell them that story about how that happened. But anyway, I just tell them in the limited, I can't say one way or the other. And so I just, in that scenario, I couldn't tell them, no, offer a little bit more, or offer a little bit less, whatever. You just have to think of it as you're just the go-between. You can't really give advice to do more or less or whatever. So I just always tell them that's the scenario. Now, I very rarely have had anybody ever say, in fact, I don't know if I've ever had anybody say, no, we don't want you to act as a limited agent.
I have a client that told me that.
Did you?
I would prefer you not to get into a limited agent.
Oh, and if they do, that's fine. Then what you would do is just find somebody else at the office and go say, hey, Chad, I got a buyer for you, but you got to pay me a 75% referral fee.
Do you have to get permission from your seller?
To do limited agency?
To do limited
Yes.
agency?
And buyers.
Well, and they
right?
sign a
Yes.
contract, plus
Broker,
the-
everyone involved.
That's also different from Oregon, it's like having that in the agreement that both parties have to sign off on.
Yeah, so this is they're giving you permission, but then to actually do it, there's the limited agency
Limited
consent
agency,
form.
Right.
So this one is, we're just saying, hey, this is a possibility.
Possibility.
But if like Luz was saying, if for some reason they said, well, I don't want you to do that, you would just have to then say, okay, well, if that scenario comes up, then I charge a higher commission. All right, section 6, expiration. This section is just saying that the expiration date will automatically extend to the closing if the property goes under contract. So that way we don't have to go do an extension, meaning like if our contract was going to expire today, let's say it was May 31st, but we were set to close on Friday, we don't have to go do an addendum extending the listing agreement because we've already agreed that whatever the purchase contract closing date is, this will extend to that.
So that's different, right?
Expiration's about in this one.
Oh, is it not?
Because it says in here, professional
I guess I
advice.
do need to do the updated on this.
Yeah, but this one is 2020, it says on the bottom.
All right, well, we took it out apparently. Moved it somewhere else.
You need an addendum now.
Yeah, now you would need, no, I think it is still in here. I think it just got moved to a different spot. I'll have to look at that and see it. All right, good to know. Thank you. All right, section 7 or 6 for you guys. Next section, professional advice. When sitting down with a seller, when I get to this section, here's how I explain it to them.
It's right under, in the term of the listing, it's right under the expiration date where you put it down. It says it right there.
Oh, perfect. Yeah, so we just moved it to, from there
Which
to
makes a lot of sense.
to section 1. Yeah.
Yeah.
Okay, thank you. So when I get to the professional advice section, what I always tell the clients, whether it's a buyer or a seller, when I get to this section, that what this section says is don't believe anything I tell you. That's how I always start it with the client, is don't believe, which usually kind of gets their attention a little bit of like, what? And so then I just say, basically what it says is I'm trained in the marketing of real estate. I'm not an attorney. I'm not a CPA. I'm not a property inspector. I'm not a surveyor. Like any of those types of the things that you have questions about, you're going to want to ask me, but I am not the expert is what this section says. So to some extent for you guys, this professional advice section is a little bit of your get out of jail free card. Is if they did try to come back and say, well, you told me I wouldn't have to pay capital gains on it, is we would rely back to this of like, but we also told you don't rely on us, okay?
It's like 2 sections of that, right? Or no, maybe that is the one I'm thinking of. I could have sworn there's like a whole other section of the same thing.
So
Like, do
in,
not
on
listen
the
to
buyer
contracts.
due diligence form, there's a separate thing, so that's probably what you're thinking of, yeah. All right, next then is dispute resolution. On the dispute resolution is just saying that we will go to mediation before we go to court. So remember in the REPSI, it has the box where you'd either check shall or may. On this, which is the contract between us and the seller, we're saying we shall. So this is a, we shall go to mediation before going to court, okay? So that's what the dispute resolution section says. Next one is attorney's fees and governing law. Says that in the event we do end up in court, the prevailing party is entitled to reasonable attorney fees. So I have a friend who was a part owner of a title company that ended up getting, he left a title company to go start one, to be part of a part owner of one. The company that he had left then sued all the owners of this new title company, saying that they had breached their contract by going and starting their own title company. And so they got sued by First American Title. First American then won and then went back and said, now, not only do you owe us the money for taking clients, basically, you now owe us for all of our attorney's fees. And they won that as well. And so anyway, he ended up having to settle out of court with it and kind of a crazy thing. But just my point in telling you that is, this is like real, is like it, in the event the prevailing party goes and says, now we want to get paid, reimbursed for our attorney's fees, that happens, okay? All right, next, advertising and seller authorizations, okay? This next section here is going through and basically the seller is giving us authorizations to go and advertise the property. And then it goes through and lists each of the things that they've given us. So let's talk about section A there of advertising seller authorizations. To disclose to the MLS after closing the final terms and sales price for the property consistent with the requirements of the MLS. So why do we need that? Why do we have to get permission from them to do that?
We hate the MLS. Just kidding.
Because what?
I said I hate the MLS for that reason.
Why?
I guess in this case it is, but the whole thing of like, oh yeah, the second get it signed, even if you're not going listing, you have to like send us all the copies, everything, like. So
Okay,
it's just, we're like partnered with them, right? Or like official, or some crazy partnership with them somewhere.
somewhat, yes.
And that's where it comes from.
Okay, that's not why we need this. You're correct, but that's not, why do we need permission to disclose it to the MLS?
Oh.
Yes, because Utah is a non-disclosure state. So without permission from the seller, we could not put on the MLS what the final closing price. So what if you had a client who said,
No.
I don't want you to disclose what, even on the MLS? So yeah, there is a form from the MLS that you have to fill out that says that you're not disclosing it. Now, why would
We
we?
shouldn't take the listing.
Yeah, to some extent, don't go about doing that. We don't want to go not putting, could you imagine if nobody ever put their sold prices?
Then
That would really mess up like point costs.
It would screw us up big time, right? So we need that, but what would be a scenario that somebody might say, I don't want to disclose it, and that we would say, yeah, it's probably a good idea not to?
Get a more situation.
Okay, possibly,
Michael Jordan, crazy kid.
okay?
In an NDA kind of situation.
Yeah, so all of those things possibly could be one, and another that I've seen, and this is more so what I've seen when it's happened, is if somebody is doing it like they're selling for way, way cheap. And it's a scenario where Like where I saw it was 2008, 2009, where prices were just crashing. And there were people that were like, hey, this is a second home, I gotta get rid of it, like, I don't care, get me an offer. But then we didn't want to disclose, because then now all of a sudden an appraiser is seeing that and going, oh, okay, home prices are really dropping like crazy, so anyway.
It's just like an outlier.
Pretty rare. Yeah, that's the time to do it, is if there's some kind of a scenario that makes it an outlier.
So that will be to a certain degree considered as a service to the appraisers. So there won't be such a terrible low.
But I would say it's more of a service to the clients and to us than the appraiser.
It's just like,
Future sellers, future.
Yeah.
Right.
Yeah,
So this case, you would already want to like have a buyer in this case, right? Because saying like, how are you gonna market something if not marketed, like put it aside the front door
well, no, I'm just talking about just disclosing the purchase
to
price.
the MLS only?
Yeah, when it
Oh.
closes, that's all we're talking about here is the closing. Yeah, this is just saying that after it closes, that we can disclose to the MLS the final purchase price. All right, then it goes through and lists a bunch of other things of like, where did you get the square footage from? And which is a little ironic, because the seller has to disclose to us where they got the square footage from, and where do they usually get it from? From us. So it's kind of a little ironic, but you're gonna put that in there, and then it goes through and talks about that we can have a key to the property, that we can put a key box on it, and we're not responsible, which I always point that out to the seller. Make sure you point out to the seller that we're not responsible if something gets stolen, something gets broken, any of those things. And so I always use this as an opportunity to tell the seller, if you have things you're worried about getting broken or stolen, get them out of the property now. I had a few years ago, an agent here call me up one day and said, hey, my seller has like one of those office fridges, like a fridge that you would have at the office here, in their bedroom. It was in their bedroom at their house. And they kept like $600 cash in that refrigerator for some reason. Well, somebody had shown the property, and then the seller called our agent saying that I had $600 in there and it's gone.
first of all, why wasn't in there?
Yeah, exactly.
Second of all, why wasn't it locked?
Right.
Third of all, why
But so I
wasn't
said to the agent, did you make sure to point out to them when you listed the property, the section that says we're not responsible if something gets lost or stolen? And he said, yes. And I said, well, then unfortunately, you got to go back. I mean, I said, you can call the agent that showed the property and say, hey, there's $600 missing. But more than likely, they're going to say, I didn't see anything happen. And they probably didn't, if the client took it or whatever. I mean, could have had a kid with them that just opened the, I mean, think about it. If you had a kid and they open up if they see a little fridge in a bedroom, they're going to open it to see what's in there. And if they see cash, they might go, oh, I'm taking that.
So I have a client that he had like guns, rifles, and
Yep.
things of that sort. And I advise him to either get them out of the property or hidden somewhere, because there is a liability issue if a child gets shot with something they find in the property.
Yeah, they would definitely, the seller would have some potential liability, but that's again, yeah, for me, if you're worried about drugs, guns, like any of that kind of stuff, get it out of the property or have it locked up, like you say, to where somebody, you know, in a gun safe or something, but we're not responsible, is basically what this is saying, okay? All right, they give us permission to hold open houses, put signs on the property, order the title report, a home warranty, that we can communicate with them. You know, all of these kinds of things are part of this, okay? All right, next. Personal property. The next section is, oh, sorry, this is where I always point that out, is telling them that they're acknowledging that we have discussed with them the safeguarding of personal property and valuables. So again, this is where I'm telling them all of that stuff. They're responsible, not us. And so make sure you just get rid of it. So in that scenario, the agent, I said to the agent, you got to just call back and say, I'll call the other agent, but like, we're not responsible. You know, you shouldn't have had it there. So, all right. Next is attachment. So the next section of this is the attachment. So you're either going to check that there are not additional terms in an addendum. Most of the time, you're going to check that there is not. Some of the scenarios that you might use where you would check that there are would be, let's say it was a for sale by owner or whatever. You just go to meet with the seller and they're saying, I want to list it with you, but I have this other person that's thinking about buying it. And so I don't want to list it for a week or 2 weeks until they either decide they're going to write an offer or not. Well, in that scenario, I would say, let's just exclude them And so I would check the box so that there are, that there is an addendum. So you check the box for R, do an addendum, and I'd say that the contract excludes this person for 30 days or 2 weeks or however long you're gonna do it for. Does that make sense? So just pretty rare that you end up doing an addendum, but if you did, that's where you would do it. Okay, section 13 is equal housing opportunity. Basically, I always tell the seller what this says is that we can't discriminate. We have to follow all of the fair housing laws in terms of you selling the property. And so if you have a client that ever says anything like, I don't want to sell my house to, and then fill in the blank, whatever protected class you want to put in there. What?
Plug your ears.
Yeah, that you would just say to them, look, for me, I always just said, at the end of the day, their money is green, so it doesn't matter who buys your house, because at the end of the day, their money's all the same, okay?
Have you
So-
run into that a lot?
Not really. The house that we did the CMA on, when I sold that one, my wife did say, I want to sell this house to, I want to make sure that it's somebody that's going to take care of the house and keep up on the yard. And, you know, she's like, I want to be picky about who, and I had to say, we can't, like,
Yeah.
you just, if the offer's acceptable, you gotta accept it. So,
Really?
yeah.
It's like borderline, right?
So my wife's probably the worst one.
Cause that's still like in compliance, like, oh, I just want someone who takes care of the property, right, compliance wise, but that's like you rate on the line of like, one more word you say could throw us on the.
Exactly, that's just it, is it kind of just like, I mean, there's nothing wrong, there's not a protected class of how well they take care of a property, but like,
What about like choosing, you want someone who's going to live in the property versus someone who's going to buy it? It's like,
I hear that a lot, actually.
because I've had, my buyers. who chose to go for investors because they-
yeah, investor's not a
Those are
protected class, so, I mean,
So it's only referring to protected classes.
But
Yeah.
I think it's a little different too, if you have multiple offers compared to, you have one person
Right.
who wants to combine
Right.
a house and you want to discriminate for one reason.
for one reason or another,
If
yeah.
there's
so-
other offers, you can just say, this is the one we invested on.
Yeah.
But- And I guess to me, if I had somebody that was saying, I don't want to sell it to an investor, I would just say, okay, but to some extent, why do you care? Like,
I think people get like, it's like further emotional involved.
yeah, I totally understand why,
Oh, I see what
but I'm also like, what I mean is I'm saying, well, but how do you know that whoever we sell it to isn't a month later gonna decide, I decided I want to rent the property, like you, unfortunately, there's not a whole lot you can do. And so to me, I just try to keep on relying on what you need to care about is the money part of it, you know, because you just don't know. I mean, and I get it, like I say, because typically it's people with ours, what we were noticing is the people who had initially bought and built those houses all took care of their yards. And every time somebody sold and moved out, the people moving in didn't seem to mow it and keep up on the weeds. And so my wife was more like, I just want to make sure our neighbors still get somebody that takes care of the yard. But I'm like, how do you know though? Like, you're never gonna know. I mean, I guess you can go look at their car, but at the end of the day, for me, I was like, I said to my wife, so what you're saying is if somebody offers us more money, but their car's a mess, you're not gonna sell it to them? Well, no, I would sell it to them. Okay, well then who cares? It's just they try to, want to keep up on the neighborhood. All right. Electronic transmissions and counterparts. This is just saying we're agreeing we can do all of this. The counterparts section really doesn't apply too much anymore. What that really was put in there for was used to be that all the offers and stuff would come via fax. And so a lot of times you'd get an offer in and then you'd fax it to the buyer, to the husband and the wife of the seller. And, they were both at work or whatever. And so you'd fax one to him, one to her. They would sign it and send it back. As long as it's the same document, that's what counterparts would be, is that their signatures don't have to be on the same piece of paper. But if they were photocopies of the same thing, is what counterparts mean. So, but essentially it's just, we're saying electronic transmissions works.
That brings a good question too, because it does happen. So say like, I say the same thing with dot loop, like I send it to the sellers and then they sign it. Or maybe I sent to my buyers first and then like I change like one little word, so it'll clear their signature, but then the seller signs that one. And then I just have another one, I like fix it real quick and then they just sign, so now I have a signed copy from the seller and a signed copy from the buyer. Is that okay, or do you have to like?
As long as it's the exact same document, meaning it doesn't have to be the same piece of paper, but nothing's changed on the document, that's where the counterparts would come
And
in.
then from there, you can just like put it together, right? Like
Uh-huh.
if I have one with one signature on the other, I can just sort of like. Put
Yeah.
it together.
Yeah, like if
No
you,
one's gonna
let's say you had, the
freak
client
out.
had signed on dot loop. But you had left the office before they did, and so you had printed off a copy and went and met with the spouse. And they signed the one you got, and you got back to the office and now the one signed in dot loop. But it's the same document.
Yeah.
We wouldn't need to do anything differently. That's what this counterpart's is saying. They both signed the same document, it's just not on the same piece of paper.
How about the same date? Do they have to be the same date?
No,
That's what I thought.
Yeah, no. As long as it matches, everything's exactly the same. I did have one time that what happened was the agent had left the addendum that they needed signed at the office. And so when they got out to meet with the seller, they realized they forgot it. So they pulled out a blank addendum and rewrote it and then called me and said, is that gonna be okay? What do you think the answer is to that?
Is it identical?
That was exactly what I asked them. Is it identical? And they said, yes. And I said, then it would be fine. And then when I saw it, it was not identical. And I was
So
like,
what
so,
happened?
well, I said, you gotta go fix it because it's not the same. It clearly was not the same document.
So she had to go, or whatever,
Yeah.
whoever that was.
They had to go
again.
actually go do it again and get, so there were the same one signed. Yep. All right, next, due on sale clause. So when I get to this section with the seller, what I always do is explain to the seller that the due on sale really only is gonna be an issue for them if they're gonna do a seller finance or a lease option. If they're not doing that, if they're just doing a traditional sale, this due on sale clause doesn't really mean anything. But essentially, the due on sale clause is just saying, in the event that the seller found out they had done like a seller finance on it, the lender could come and call that note now due and payable. So, did you have a comment? Oh, I thought I saw you.
Seller,
This is
you said
just-
seller, seller finance.
Seller finance or a lease option.
Or lease option.
That's only because title like takes care of that, right? Like when they do a title where they see that lien, they pay it off, right?
What do you mean?
It's like I do, like I said, it's only really relevant if there's like for sale by owner, and they're kind of cutting out a lender and title beat, whereas on title people, just because no one really knows. But on a standard one, getting a mortgage with a title, they're gonna see, okay, there is an existing.
Oh, yeah,
like,
they're
line,
gonna
and
pay it
we're
off.
gonna pay it off.
Yes,
So, like,
exactly.
yeah, that's what doesn't matter.
Yeah, that's why it doesn't matter. If they're doing a traditional sale, it's gonna be paid off. There's no big deal. But in certain transactions, that could become an issue, which I'll be interested to see what happens. If interest rates keep going up, it'll be interesting to see what creative things come about that would enable somebody to go just take over the seller's current mortgage that's got a 2 point whatever interest rate.
Do that?
What?
You can do that.
Well, yeah, you'd have to be doing a, seller finance where it's kind of a wrap
Oh,
around.
Interesting, would they tell me? That's, I have a lot of questions.
Well, so what you'd have to do is you'd have to go in and say, we'll take over your mortgage. We'll just keep making your payment that you currently have. And then they would have to either have cash or go get a second mortgage for the equity that's in the property and give that to the seller. So
Like
I-
a bad map for all of
But it would
this.
have to be the right situation.
Yeah.
Like, I think of our situation where we couldn't have afforded our next place with that mortgage still on our.
Right.
Property. So it's not gonna work for everyone.
Right.
no, yeah, it's not gonna work for everyone, but it'll be interesting to see if that happens. I mean, if interest rates all of a sudden are 8% and as a seller, you've got a mortgage that, I mean, like I say, it's not gonna be an easy scenario, because by the time you go get, if you have to go get a second mortgage for 200,000, but it's gonna be at 10% interest, it might not balance out, but it'll be interesting to see if that becomes someone. All right. Next is Foreign Investment in Real Property Tax Act, so it's called FIRPTA. And what this is, FIRPTA is basically, and this came about again because of 2008, 2009-ish timeframe. What happened is you had, and this applies more so to Park City than what we would see down in Salt Lake, but there were a lot of people who had bought properties in Park City. And then again, 2008, 2009, people were just liquidating kind of everything. But they were still having a capital gain on it. But if it was a foreign person, meaning they didn't have a tax ID number or social security number, the IRS had no way of going and collecting taxes on the gain that they had had. And so what happened is in 2008, the IRS changed the way that the tax laws on that worked to where basically what it said, and this is the Foreign Investment and Real Property Tax Act that Congress put in place, that said the buyer of a house, so make sure you follow me on this, the buyer of a house is responsible to make sure that the seller of the property, if they're a foreign investor, has either a tax ID, well, if it's a foreign investor, they have a tax ID number. If the buyer doesn't, and they sell the property and owe taxes, this Foreign Investment and Real Property Tax Act says the buyer has to pay it. So if the buyer doesn't ensure that the seller has that, the buyer has to pay it. And there was at least one that I know of up in Park City where the IRS came back to the buyer, or excuse me, the buyer saying, you bought this property. The person who was the seller was a foreign investor and they didn't pay their taxes. You now owe $30,000 in taxes, which they then went and tried to sue the title company. And I don't know what ended up happening with this.
So the title company would be able to tell you that, right?
Yeah, so what happens, which we don't really worry too much about it now, but when this first came about, we always had the seller sign something saying they've either given the title company their tax ID number or they've given it to the buyer. So that's the way the law actually is written, is the seller has to either give to the buyer their tax ID number or social, or they have to give it to the title company. So I think now the title company is just, it's been all incorporated there because we don't use a form anymore. But on this one, you're gonna have the seller check the box that they either is or is not a foreign investor.
So,
Yeah.
so what happens if they say they are not? They are.
If they're not, then at least we're removed from it because they lied to us.
Okay.
I mean, they don't have to give it to us, they have to give it to the title company. So
But this is something that, in the event that this occurred, this would be something that, if you're representing a buyer, would fall under the finance and appraisal.
it's more an issue on the buyer side than us.
Right. But that's also in the seller's disclosures too.
Yeah, correct.
So
So
we are not getting the seller's disclosures.
we are. It'll be fast. All right. The next is this is the entire agreement, that anything that we have agreed to is in writing and all that. So then they're gonna sign and you're gonna sign as the authorized agent. Now, before we turn the page though, notice in red here, it says, do you have a real estate deed, a property to sell or purchase outside of the market area? That's just there as a reminder for you to ask the client, do they need help outside of our market area? Because if they do, then send it through our relocation department. You can get paid some money on that as well. All right. Problem reading this document. Uh-oh. What? See if I can pull up a different version of it. Blake kind of looks like Sheldon. Not Blake Sheldon. It's like Chris Sheldon. Isn't he?
And maybe like when he first got out of the show.
That's true. All right, let's see if this one works better. Oh, this is the one I should have had pulled up to begin with anyway. This is the correct one. All right. Here we go. So the next form is the residential listing input form. So on this, here's the only thing I'm going to point out for you guys on this, since we're running out of time here, is anything on this that has a little dot right next to it. So you can see list price, short sale, but under lease considered, there's no dot, no dot. There's a dot here, there's a dot there. anything on this form that has a dot next to it, you have to fill out. Okay, so when you're filling this out, if there's not one of those little dots next to it and you don't know the answer, leave it blank. If there's a dot next to it and you don't know the answer, you gotta go figure it out. So, for example, the short sale, you need to know it's either not a short sale or it is, and what the scenario is, okay? Same thing with the schools. These are all the things that are gonna be required that you put in, okay? So as you go through that, fill it out. And then here's what I will just tell you on this. As we go through this, let me scroll down here to these checkbox sections. When you get into these sections, I always, as I go through and look at the property, I will check the boxes as I go around and look at the property with the seller. But at the end, I always just say to the seller, take a look at this and see what I missed. Because guaranteed, I don't think I've ever gone through and checked it and not missed something. The seller knows their house better than you do. And so I just always tell them, look through there and see what I missed. And then what happens is they'll look through it and they'll get to something like this and they'll go, oh, we have outdoor lighting. And then I just say, great, check the box. So I just have them go through and check whatever I missed. Okay. As far as remarks go, anything you put in this remarks section will show up for the public. The agent remarks will only show up on the MLS under the agent remarks section. And then directions, non-standard address, used to be that we would use that quite a bit if it was, the property was hard to find. For the most part now, any property that you list, people are gonna just plug it into their phone and be able to get there. But every now and then it doesn't work. So I told you guys the story about the cabin up Big Cottonwood Canyon. When you plugged in the address, if you followed the directions on your phone, it didn't take you to the property. So in this non-standard address direction stuff, I would put in there, you know, hey, if you're following the map on your phone, it's gonna drop you off here, and it's actually the property just down the street or whatever.
But agents still won't read it anyways.
I know, it's true.
So
But at least you have it in there when they call to complain, because you couldn't find it.
Our condo, it always takes you back, not to the front,
Yeah.
and you never get in, so I wrote it on that when we listed ours.
And then people still call
go
you.
to the back.
Yeah.
Like, so how do I get in? I'm like,
Go to the
it's on
front.
the MLS. read
Use your
it.
resources.
So in this, you said just to fill out where the black dot is,
Yes.
the other that doesn't have it,
If it doesn't have it, it's not required. So if you don't know, it's okay to leave it blank.
Oh,
But if you do know, if there's not a dot and you know the answer, put it in.
okay.
But if you don't know, it's okay to leave it blank.
All right.
Does that make sense? All right. Exclusion remarks, just put in anything that has to do with the exclusion and HOA, whatever you want to put in about the HOA. Then they're gonna sign. All right, next, seller property condition disclosures. So on this, when I get to this section with the seller, I always tell the seller, this is the most important form you're gonna fill out. So for the sellers of everything they're gonna sign, I always tell the seller this form, if you end up in court, this is gonna be the form that either sets you free or that hangs you. So I always tell the seller, fill this out and disclose everything you know about the property. And a lot of times the initial thought that people have is, well, I don't want to disclose that we had a leak in the property or whatever it is, you know, as they go through and fill this out. A lot of times the seller will feel like, well, it's going to make my house look bad if I disclose this. Now, here's how when I really learned this was when I was at Coldwell Banker, we had an attorney on staff at the office there. And he was selling his house in Farmington and moving somewhere down here. But he had a buyer come along that didn't have an agent and wanted to buy his house. So he was going to sell it to these people. And they then told him they were not going to do an inspection. And he told me, he said, I went through the seller disclosures and I checked yes on almost everything. He said, I went through and put down, yes, we've had, you know, whatever it was. Like, I mean, he didn't do it on every single thing, but he said, if there was ever a question on if this potentially could be an issue, he said, I checked the box yes. Now, I'm not telling you guys to go tell your clients to put yes on everything, but here was his logic is, if you have disclosed it in the seller disclosures, it totally removes from the seller the responsibility of there being an issue from it. And so he said, like, every little, like the part on here about stucco, are there any cracks or whatever? He put yes. Like he just checked yes for everything that was a possibility that it could be, because he said what that does is it makes it to where the buyer could never come back and sue. Because let's say they came back and said, hey, there was a problem with the stucco. If you end up in court, what he told me is he said a judge would look at it and say, the seller told you they had an issue with it. Why didn't you investigate further? So I always explain to the seller, it's not a bad thing to check, yes, you've had a water problem, or yes, the roof leaked or whatever. Because as soon as you check that, as long as you explain what you did to fix it, you're gonna be fine. But it also then removes from you any real responsibility if there becomes a problem with it, because a judge is gonna look at it and say to the buyer, you should have checked and investigated further once they told you that. Does that make sense?
I have a question.
Yes.
So is there the same rule that there is in Oregon that if it's in a trust and you inherited it, then you can be exempt from disclosures?
So great question. So it used to be that if a buyer went and bought I'm going to use different than a trust, but let's say that I went and bought a home and I was going to go fix it up and sell it. It used to be that people would put in here, there was a spot that they could check. It doesn't exist anymore. But up here in section 1, there used to be a section that said that you've never occupied the property, therefore you're not filling out the disclosures. But the Division of Real Estate said, we got to get rid of that, because here's the truth. If I bought a property and then I'm going to go in and fix it up and turn around and sell it, I probably know that property better than most homeowners that just are living in their
But
house.
like the, not specific to like an inheritance.
Right. So, but yeah, so in your scenario though, even if I inherited that property, I still, in Utah, the Division of Real Estate still wants you to go through and fill this out, because there may be things that you do know. So I just always would tell the seller that you'll notice is it does say on here, like, let's just, with the exception of cosmetic upgrades to the property, have you remodeled or any of that? Well, even if I inherited the property, I could still say no. To your knowledge, so notice most of these will say, to your knowledge, or are you aware of?
So they just
any
kind of work
past
the
or present?
verbiage in and stuff, because like, so I inherited my grandma's house and they sold it, and so I didn't know anything about it.
Yeah.
So I filled out the exemption.
So yeah, if you were doing that with your grandma's house that you inherited, you would just say, to your knowledge, did any former owners make any additions?
Interesting.
And
Okay,
then
I
you would
like
either
that they
just
work
say
that
yes or
way,
no.
but yeah, instead of like.
So yeah, occasionally though, you still will run into scenarios where a
Oh,
seller tries to say, we're not gonna do disclosures
Right.
because we don't know anything.
there's no unknown column on this?
Nope.
There is now in the.
Is there?
Because there's the new.
Some
summers.
have-
Yeah.
Oh, that's right. I forgot. I need to update.
Yes.
We got brand new
Because
ones.
that's sick, we have.
I don't know
Yeah,
if it says
16
unknown, but it
pages.
says not applicable.
Yeah, there has an NA.
Yeah, we have unknown.
So yeah, I forgot about that. I need to update. I guess I better update this again.
I like that they have the verbiage worked in, it was kind of a pain to make sure that we could get that exemption.
But see, so that's where again though, of it, on using that as the scenario, you inherited the house. If you had any knowledge of anything, I would say check yes. Like if you don't, then you just say no or whatever.
Right.
But because as soon as you say yes, no, they could never sue you for that. I mean, they could, but they're not gonna win, because you would say, well, I did say that we had an issue.
I had a seller that when we were walking around the house, there was like a watermark that there was some kind of leaking in there. And I don't know if I was wrong to ask what happened in there. Should have I, or should, he didn't point that out to it, but it was pretty obvious there was something in there.
So you were there with a buyer and you asked the seller?
No. I was going to list the
Oh.
house when we were
Oh,
doing
yeah,
the walk.
absolutely, you should. Yeah.
And I asked and I said, well, what happened in there? And he says, oh, the children just spilled some water. Obviously, it wasn't.
Yeah.
So what happens in that? I mean, I didn't say anything else, but I'm thinking.
Well,
he's-
so yeah, so in that scenario, I would, if I had walked through and said that, what happened here, and they said, oh, the kids spilled some water, I would say, well, when you do the seller disclosures, you need to disclose that that's what happened. Because every buyer, if you noticed it, every buyer walking through is gonna notice it as well,
Uh-huh.
and so they should ask. So,
And then, but the interesting part about that client is they were Spanish speaking, so they wanted me to translate for them and to help them with the translation when they were doing the seller's disclosure.
yeah, and I would tell them you need to get somebody else to do it. Because the
Okay.
problem is, if you do it, you translate for them, if there becomes a problem, they will come back later and say, oh, that's not what she told me it said, or like,
Even though it wasn't the truth, they could pin it on me.
they will try to, they will try to.
So for my own protection, don't do that.
Let somebody else do it.
Okay.
Yep, have them get somebody else to do it. for them. All right, so you're gonna go through, disclose what they know, and, oh, here's the other thing too, that for me, if I'm representing a buyer, and this is what I tell the sellers, if I'm representing a buyer and I get seller disclosures and they've lived in the house for 10, 15, 20 years, and it looks perfect, I'm more worried about that as a buyer's agent than when I get one that says, yeah, we had a water leak and this is what we did to fix it. Like,
And things happen.
because things like guaranteed, everybody living in a house for any significant amount of time, whatever that is gonna have something, you know. We had one time at our house that I'm in now, that we had left the washer, the thing came out and leaked down, and luckily underneath where our washer and the laundry room is, underneath is unfinished, so it really didn't do anything, but stuff like that happens.
So you disclosed it anyway.
Well, I haven't sold the house, and I probably never will, so he can disclose it. Anyway. All right, so what?
I didn't know that happened.
Well, now you do.
No, you don't.
So now you
So
can.
now when I inherit the house.
Now when you inherit the house.
One day, on May 31st, 2022.
Yeah, I don't know if I ever
Thanks,
will.
Russ, I gotta head to our meeting.
Okay, see. All right, so this then is an addendum to the seller's property condition disclosures. So this is where they would write any additional information. So from page whatever item number and put in their explanation. And that's what I always tell the sellers, just explain what happened. And most of the time the buyer's gonna be okay with it, but really it just becomes this thing of get out of jail free for you. Okay? All right, they're gonna sign acknowledgement and all that. All right, wire fraud or disclosure. On this one, I'm just explaining to the seller and really less of an issue with it in the seller side than the buyer side. But I just tell the seller, look, there's a lot of wire fraud that's going on. And so as a result of that, like if somebody asks you to wire money, double, triple check where you're gonna be sending it. Yeah, call and let me know. I'll find out. Like, don't wire money without checking on it. So. Because we did actually have here on this, it was an agent who had been with us and left our company. But then she was gonna buy a house from, so one of our agents here had listed it. She now is no longer with us as an agent, but she's also an investor. She was gonna buy the house and then fix it up and sell it. It was like $150,000. And somebody sent to her, hey, the wire instructions have changed, here's the wire. And send the $150,000. And she actually wired it to the wrong account. Now, luckily, it was with a title company that was in this building at the time, and they caught it within a couple of minutes and were able to get it stopped. But had it been even a few minutes longer, her $150,000 would have been gone. And so just let them know, don't wire without double, triple, quadruple checking. And we're gonna have them sign so that if they do, then do it, we can say we warned you. All right, affiliated business arrangement disclosure, you're gonna fill out their name, the property address, the date, and then what this is telling them is that they're not required to use the services provided, and that there are frequently other settlement service providers available, that because we have an ownership interest in Inspiro Financial and North Star Title, we have to disclose to the seller and the buyer that they don't have to use these companies, even though we would like them to. Here's what the fees look like so they can compare, okay? And then they're gonna sign. So they have to sign this whether they're gonna use Inspiro or North Star or not. Even if they say, well, we're not gonna use them, they still need to sign that we have disclosed to them this. And the idea of that is if for some reason something were to change later on and they decided to, then you'd have it. All right, lead-based paint disclosure. When do we use this? What?
1999.
1978.
So do I need it if the property was built in 1978? Do I need this form or no?
No, prior to that.
Good, yeah. So you use this if the home was built prior to 1978. Now, would it hurt to use it? No. In fact, I've done a lot of bank-owned properties where I would help banks get rid of their foreclosed homes. And they do one of these regardless of when the house was built. They're gonna throw in a lead-based paint disclosure. So it doesn't hurt to have it, but it is required if it was built prior to 1978. Okay, so I'm gonna, with the seller, put in the address. I'm gonna have them initial. I don't know why I did this with a checkbox. I guess just to tell you it's not a checkbox. But so they're gonna initial that they either know of lead-based paint or they have no knowledge. They're gonna initial that they have provided the buyer with the reports or that they have no reports. And then you're going to initial as the listing agent here that you've informed the seller of their obligation, and then everybody gets to sign. Okay? And with that, we're done. Questions?
So in here, in this one, last one that you did, you put a, or who's the one that signs the presence or no presence, is that the seller? In the lead disclosure that.
Yeah, the seller's gonna initial that section, that they either know of lead-based paint or they have
So
not.
they are the ones checking that, or who checks that?
The seller initials. There's no check. It shows a check on there, but there's no check. It's seller's gonna initial it.
Or just initial?
Yep, just initial.
Thank you.
You're welcome.
Okay.
Okay, for you guys on Zoom, if you didn't throw your name in the chat box, make sure you do, because that's the only way I have proof of who attended. So if you did not put it in there, and then I tell you you didn't attend and you say I did, I'm gonna say, I don't have you in the list. So make sure you throw your name in.
Ross, question for you. I
Okay?
know that every training we focus a little bit on different issues depending on the questions
Uh-huh.
and depending, is there any more recorded of past trainings on the Rep C and all of that that
Uh-huh.
you went through?
Yes.
Okay,
Yeah, I actually just uploaded it today. The one that Rob did on Friday is on our YouTube channel. So
okay.
if you just go to YouTube and search Century 21 Everest Training,
Uh-huh.
it'll bring up our channel, and that should be the first one that's showing there right now.
Okay, no, but what I meant, because
Oh,
you just
sorry.
went through the seller's
Packet.
packing, do you have like any other training already in there that you have done in other?
Uh-huh.
Because,
For the seller packet, is that what you're
yeah,
asking?
for the seller
Uh-huh,
packet,
yes.
because I noticed.
Every time I do teach it, I will record it, put it on the website. So there's a bunch of it.
Okay, and then I suppose that we always refer to the more recent ones, right?
Correct.
But it wouldn't hurt to just listen to the other ones.
No, wouldn't hurt.
Okay, because
Yeah, because
I,
there'll be different questions and things that, come up.
Yeah.
For sure.
okay,
Yep.
Thank
good.
you.
You're
Thank you.
welcome. Okay, see you guys. Thanks for being on Zoom.